truth, logic, common sense, that gut feeling, and yes, even a little psychoanalysis, as we are once again together, you and I, to discuss Chad and Lori Daybell. You think Chad's at this point now where, his Johnson's not doing the trick for him anymore and he wants to get away from his queen? Happy Monday, everyone. There's Columbus Day, Indigenous Day. Well, KJ says it's Happy Human Day every single day. We were all made. Every single human being on the planet has been made in the image of God. And so I celebrate life and I celebrate each and every one of you. So we're here and we're going to go over this whole motion for severance of John Pryor, which will be heard on October 13th. That's 3 days from now, y'all. Of course, we're not going to be in there. It's not going to be a live audio or live cameras, but we will get reporting on it, and we will also eventually, through Nate Eaton, it'll take a couple of days, maybe the beginning of the following week, we'll get the audio recordings of it, of that whole hearing. So, and maybe some of it will be taken out. Maybe the judge won't allow this bullshit of this author wanting to go in there and try to accuse everyone of everything, and maybe all that will iron itself out, and we won't have to hear any more of this crap from this author. But anyway, back to all this. John Pryor is he's going to argue his motion for severance, and we know that Judge Boyce has doubled down on this, and it's, in my opinion, he's going to keep this case together. He's done everything he can to not have this joinder of offenses messed with at all. He's going to make sure that not only the joinder of offenses, but also the joinder of defendants, there are charges in all this, conspiracy to commit murder and all of that. So Judge Boyce is going to do it to it. Now, y'all know me. Y'all know that I usually don't give the defensive side of anything having to do with this case. In fact, I'm a proponent of the state. I'm there to cheerlead for Rob Wood, Lindsey Blake, and Rachel Smith. Also, I'm in the corner of Judge Boyce, who is a neutral arbiter of justice. He's like a referee. He's not for the state. He's not for the defense. But today, in order for me to really get down to the nitty-gritty about this joinder of offenses, joinder of defendants, I want to talk to y'all about what I said I was going to talk to you about, and that is the antagonistic defense. And yes, I will talk about another way that this case could be severed, which is what San Willow had brought up about the Bruton rule, okay? But what I'm going to do is I'm going to look at this from a defensive standpoint. Believe it or not, y'all know me. If I had to be an attorney, I'd be another Juan Martinez. I'd be out there. How many times have some of y'all said, boy, if you were an attorney, you'd dang chew them up and spit them out? Well, I'm not smart enough to be an attorney, but I do like the common sense and logic of the legalese of this case. So I am going to try to do my best to talk to y'all about it, give my opinion on how that's all going to turn out. I mean, if you really think about it, the continuance from John Pryor is a moot point at this point because Lori's case has been put on hold because of her malingering, in my opinion, her fake ass stuff. But this joinder of offenses, this joinder here, and this the joinder of Chad and Lori together in a joint trial, that could still be looked at, regardless of whether that trial has been vacated in January. So I am going to I've been studying this stuff on a state and federal level, and I ran across this article, and it was from the College of William and Mary Law School here in the United States, and it's a really prominent law school, and there was this Paul Marcus who was looking at this situation from a defensive standpoint, like a defense attorney's standpoint. And so I thought, well, this is probably the most simplistic way that I could put it. And so I'm going to read this article, and then we're going to touch on some things in John Pryor's motion for severance, okay? There was a time, not so very long ago, when courts recognized that antagonistic defenses offered in multiple defendant conspiracy trials created such a difficult dilemma for all that there was a hard rule, or at least a strong presumption, in favor of separating the defendants, severing such trials. After the United States Supreme Court's 8-1 decision in Sever versus United States, that position is long gone, replaced instead with the notion that, quote, mutually antagonistic defenses are not prejudicial per se. The decision in Sever matters a great deal and is, in my judgment, wrong as a matter of policy. Now, let's stop there for a minute. Just because I give you this defensive side does not mean I embrace this. I merely am reading this article because this Paul Marcus from the College of William and Mary Law School simplifies it to where I can understand it better. This old country girl can understand it better. But when this Paul Marcus says that it's wrong on a matter of policy, let's not forget, okay? Policies, they are only documents, and they're not law, but these policies can lead to what? New laws. So when he talks about that, the policies are wrong as a matter, as a matter in it, then, I think, well, he's given his viewpoint here. But laws are set standards, principles, and procedures that must be followed in society. Law is mainly made for implementing justice in the society. So there is a difference between policies and law, but policies do translate into that laws can be made from them, okay? I hope you understand. So he says he disagrees with that. He says he disagrees with this United States, Sever versus the United States. The justices were again highly insensitive to serious defense claims. Here that problems can arise in multiple defendant criminal trials. Let me state at the onset that I am not suggesting that the presumption generally as to single trials for multiple defendants is somehow misguided or inappropriate. The rule has been around for many decades, and in the vast majority of cases, little concern is raised as to such joinder of defendants. Sever, however, did not involve the usual sort of joinder. Here, at least arguably, the issue was one of antagonistic defenses, and in such a situation, the strong presumption of joinder ought not to be the standard. Now, he's talking about how did the antagonistic defense and all this, what was this case? And this was the Sever versus the United States that basically made it to where now, and this is in state federal law, this is precedent, stare decisis, this has been going on, this right here has set the standard for antagonistic defenses to not be prejudicial per se. There are many multiple defendant criminal trials, and it would be impossible to have severance allowed in all such cases. Justice Scalia, almost 30 years ago, wrote that, quote, joint trials play a vital role in the criminal justice system, accounting for almost 1/3 of federal crime trials in the past 5 years. And as he pointed out, quite a number of those trials can be extremely large. Quote, many joint trials, for example, those involving large conspiracies to import and distribute illegal drugs, involve a dozen or more co-defendants. To routinely grant severance in all joint defendant trials would be terribly disruptive, with little benefit even for the charged defendants, Scalia wrote. Still, what has happened since Sever is quite striking. Defendants rarely have severance motions granted. leading some courts to write that it would be in rare cases, if ever, where a district court should sever the trial of alleged co-conspirators. And remember, this is a district court in Idaho. And severance motion denials are not at all limited to the non-antagonistic defense cases. There are numerous cases, usually relying on Sever, where trial judges do not grant motions to sever, even with an offering of an antagonistic defense. But what we're talking about today is that John Pryor has brought up in his motion the antagonistic defense, and what they're saying here is even if one isn't presented and these case and other cases are joined, that doesn't mean it has to, have anything to do with antagonistic defenses. But we're going to learn about them today. Since Sever, we have consistently held that blame shifting among co-defendants without more does not mandate severance. In other words, if Chad is trying to blame Lori and Lori's trying to blame Chad, that can't be, if you take that in and of itself, it's not going to sever a case. The result in Sever was neither inevitable or necessarily predictable. As the case developed, two things became clear. First, the defendants in the case did not really raise antagonistic defenses. And we're talking about Sever, this case that Judge Boyce is going to have to look at in terms of whether he's going to let John Pryor sever this case if he wants to say it's antagonistic defense. True antagonistic defenses in multiple defendant trials are not terribly common. As pointed out by Justice O'Connor in her majority opinion and Justice Stevens in his concurring opinion, a true defense which is mutually antagonistic to another defense means that acceptance of one defense necessarily precludes acceptance of the other and acquittal of the co-defendant. The defense must be mutually exclusive. In other words, they've got to be exclusive. Chad's got to be exclusively defending whatever it is he's defending, and Lori's got to be, in order for it to be mutually, actually antagonistic. Okay, now I'm getting a little, okay. The defendants must be on an evidentiary collision course. In other words, the evidence there has to, it's not the same. It's this collision course of two different defenses. It's not just the finger pointing. It's got to be two sets of evidentiary things that the defenses do differently, that they're coming and they're going to butt heads. It is not enough that there be conflicting arguments. Okay, conflicting arguments by John Pryor and Archie. Or that there is finger pointing by each side. In Sever, neither defendant involved testified, okay? And each defendant claim was simply that the government had not shown his guilt beyond a reasonable doubt. So I guess the question is, would Lori testify? Would he testify? The essence of this position was that the individual defendant did not know the contents. Now listen, this is the meat of this case that's going to determine whether Chad and Lori get severance. And I'll have to try to explain it the only way I know how. But in Sever versus the United States, it says the essence of their position was that the individual defendant did not know the contents of a box. So you think about that. There was more than one defendant. There was two defendants. One of them said, I didn't know there was drugs in that box. And the other one didn't have that, which contained a whole lot of cocaine. And as Justice Stevens wrote, the trial judge was correct in concluding that the defenses presented in Sever were not mutually antagonistic. When two people are apprehended in possession of a container filled with narcotics, it is probable that they both know what is inside. Now, stop, because there's no drugs in a box in this case of Chad and Lori. But both of these defendants, right, they were caught with these children's dead bodies, okay? And first and foremost, Lori was the mother of these children, which is far more incriminating than Chad. But Chad had to have known because the children were in his backyard. Now, you could say, well, the defense could raise reasonable doubt that Chad had no idea that those children's bodies were back there. Well, I guess then you'd have to disregard the raccoon text. You'd have to disregard Alex's presence on the property right within a 10 or 11 minute span of Chad being texting Tammy and all that, okay? The inference, remember we've talked about healthy inferences, okay? And here's an example of that. You could fall asleep on the beach, and you're asleep in that chair, and you're right there on the shoreline, and there's no footprints in front of you or nothing, and you fall in a deep sleep. When you wake up, you see footprints going by that are there that weren't there before. Then you can have a healthy inference that somebody walked by. That's an inference. The inference of knowledge is heightened when, as in this case, both people flee when confronted by police officers, or both people occupy the premises in which the container is found. Okay, now Lori she wasn't in Chad's house at the time they found that body, but she was what? She was already arrested and everything. She wasn't living with Chad at any time. But here's what I'm trying to say on that. When it comes to both people occupy the premises in which the container is found, both people were in Hawaii. And when it talks about the heightened knowledge, both people flee when confronted. Did Chad and Lori, did they flee Idaho, where the bodies were eventually found, and go to Hawaii? They both fled. They both did that together. The mother of these children fled. If she didn't think those children were dead, why would she flee off somewhere without, oh, Chad, you and Alex put the kids somewhere. If we're going to go to Hawaii and run from the police, we need to have the kids with us, or whatever. At the same time, however, it remains entirely possible that one person did not have such knowledge. And I'm sure that Chad is going to say he had no knowledge at all what Alex and Lori had done, and that he had no knowledge of the kids being in his backyard. That, of course, is the argument made by each of the defendants in this case, that he or she did not know what was in the crucial box or suitcase. So Chad is going to say, I did not know those children's bodies were in my backyard. And Lori's obviously the mother of those children. Can she really say she didn't know those children were back there in the back of Chad's property there? Okay? And remember, we don't know all the evidence, so we don't know what Lori knew. All we know is a mother of these children went off to Hawaii without a care in the world. They ran from police. She lied to them initially and then took off. Most importantly here, it is also possible that both persons lacked knowledge of the contents of the relevant container. And that would mean that Alex was the only one that did all this, and that Lori and Chad had no idea that the children were dead and buried in Chad's backyard. And you know and I know, just from the information we know, that can't be possible. Moreover, that hypothesis is compatible with individual defenses of lack of knowledge. There is no logical inconsistency between a version of events in which one person is ignorant and a version in which the other is ignorant. Unlikely as it may seem, it is at least theoretically possible that both versions are true and that both persons are ignorant. Anything's possible, right? But you got to take into totality the evidence here of Chad and Alex and Lori, all of them lying to police. and then eventually taken off. Alex even took off. He didn't go to Hawaii, but he took off in another direction. In other words, dual ignorance defenses do not necessarily translate into mutually antagonistic defenses. So even if they did, even if Lori and Chad said, we had no idea that Alex would do this, that still can't be mutually antagonistic defenses. As that term is used in reviewing severance motions, because acceptance of one defense does not necessarily preclude acceptance of the other and acquittal of the co-defendant. The defendants could not satisfy the collision course requirements for antagonistic defenses, nor could either of them actually articulate any specific instances of prejudice. In short, this was the perfect case for the court, acknowledging the inherent difficulties with multiple defendant conspiracy trials, to recognize the general preference for joint trials, and in Justin Stevens' words, save for another day evaluation of the prejudice that may arise when the evidence or testimony offered by one defendant is truly irreconcilable with the innocence of a co-defendant. The majority could just have disposed of the case using that approach. True, the defendants have requested a bright line rule, quote, mandating severance whenever co-defendants have conflicting defenses, unquote. The court could easily have rejected such a rigid rule and have deferred consideration of that requirement. Instead, the majority strongly reaffirmed the preference notation, bringing within its cases involving antagonistic defense was actually stated. As noted above, prior to Sever, many courts had at minimum been favorably inclined to grant severance motions if true antagonistic defenses were presented. The Seventh Circuit opinion in Sever made this clear. A vast number of cases say that a defendant is entitled to severance when the defendants present mutually antagonistic defenses in the sense that the acceptance of one party's defense precludes the acquittal of the other defendant. This is no longer true. Instead, today the norm is to hold that severance is not mandated whenever co-defendants have conflicting defenses. How did this state of affairs come about? The reason is rather plain to see. The court in Sever was hereto dismissive of the defense's concerns. To be sure, not only did the justices not find a mandatory severance requirement for cases involving antagonistic defenses generally, severances may not be needed even if prejudice can be shown. Instead, relief is left to the discretion of who? Of the trial judge, likely to be in the form of jury instructions. The decision was certain on this point. Quote, moreover, even if there was some risk of prejudice, here it is of the type that can be cured with proper instructions, and juries are presumed to follow those instructions. Here in the court's description of the instructions, the jury received in Sever, the district court properly instructed the jury that the government had the burden of proving beyond a reasonable doubt that each defendant committed the crimes with which he or she is charged. The court then instructed the jury that it must give separate consideration to each individual defendant and to each separate charge against him or her. Each defendant is entitled to have his or her case determined from his or her own conduct and from the evidence that may be applicable to him or her. In addition, the district court admonished the jury that opening and closing arguments are not evidence and that it should draw no inferences from a defendant's exercise of the right to remain silent. Now, what does all that say? What that said is basically, if John Pryor's talking about this will be too prejudicial or this would weigh more heavily on my client than it would his co-defendant there, or vice versa. He even takes up for Lori's constitutional rights in his motion to sever. The bottom line is his jury's instructions can handle all of this. So let's look at it. The antagonistic defense, again, y'all. The test for severance based on antagonistic defenses is whether the conflict in the defendant's respective positions at trial is such that, considering all of the other evidence in the case, a defendant would be denied a fair trial. Merely contradictory testimony or different trial strategies among the defendants does not necessarily result in prejudice to a defendant sufficient to require severance. So if John Pryor and Archie have totally different defenses, and even if their defenses, they're different and they're pointing fingers at one another, that doesn't at all prejudice the situation per se, and it does not mean that that is antagonistic if what? All the evidence that's brought in lines up for both of them. Think about this. When Lori got into Idaho, she and Chad did everything together. Everything that happened. They were together on and off before Tammy was murdered. They're going to have to prove Lori helped Chad murder Tammy in terms of conspiracy. Everything that Chad and Lori did from Idaho on into Hawaii and all of that, it all lines up. The evidence lines up. It's all duplicative. And so if it'd be different if there was lots of different evidence for Chad and lots of different stuff for Lori. Now remember, when I say different, Lori is charged with Social Security fraud. Chad is charged with insurance fraud. Those are different. The specifics is different, but it's still a form of money fraud. And in fact, those charges in and of itself are going to be factors in sentencing. Remember, to remuneration. So this is something that we need to consider. What I'm trying to say is that a true antagonistic defense would be that the evidence, the defense's strategy and all of that is so different from one another that it would absolutely be on a collision course. There is no collision course in pointing fingers. The United States Supreme Court made it clear, anyone and everyone who's in a conspiracy with someone else, it'd be easy for them to say, no, my co-defendant did that. And the co-defendant could say, no, I did that my co-defendant did that. So they understood the logic of that. So I looked at John Pryor's motion to sever, and we're going to find out what the judge is going to do after October 13th in John Pryor's motion to sever. We're going to find out. But I can tell you now, it's not going to be severed. This is the perfect case for it. But in fact, it is another reason, besides the publicity of this case, that the judge did a change of venue in terms of they all the same economy, the same evidence, the same witnesses, the same this, the same that. It's all going to line up. But I'm going to pick through this motion, and I first want to start out with John Pryor's talking about this case called, it's the case of Holmes. And it talks about, in Holmes, the defendant was convicted of murder and sentenced to death. During his trial, the court denied Holmes the opportunity to present evidence that an alternate perpetrator had committed the crime under a state evidence rule that was barring an alternative perpetrator's theory there. In other words, he's talking about Holmes, and he's saying, well, they initially said that you couldn't, Chad Daybell, and he's talking about Holmes, but we're trying to apply it here. Chad couldn't say that Lori and Alex did it. But then the courts held that the accused may introduce any legal evidence tending to prove that another person may have committed the crime with which the defendant is charged, and that evidence tending to show the commission by another person of the crime charged may be introduced by the accused when it is inconsistent with and raises a reasonable doubt of his own guilt. So John Pryor's saying Chad can do this, because of this Holmes case. But let me ask you a question. What is he going to do? How is John Pryor going to introduce evidence that that Chad is not guilty and that Lori and Alex did this? These are things you need to think about. Based on the allegations in the case, one of the plainly available defenses would be to demonstrate that Miss Vallow and her brother Alex Cox were responsible for the crimes alleged and that they acted as part of their own conspiracy that did not involve Mr. Daybell. As part of the defense, Mr. Daybell would seek to introduce prior bad acts of both Miss Vallow and Mr. Cox, as well as evidence regarding their relationship and the death of Mr. Cox and the past statements of Mr. Cox. Mrs. Vallow's prior bad acts would bear upon motive, intent, and plan. And let's stop there. How are they going to get that in without Chad testifying? The state's turned over all of the discovery in this case. John Pryor would have to go and find some too that he would have to turn over to the state. And without Chad Daybell testifying, and he can testify, but there's still the hearsay rule. Only certain things are going to be able to be said. Chad Daybell can't go on the stand and say, Alex told me this and Lori told me that. That's not going to be something that can be admissible because he can make up anything that they might have said. In particular, Miss Vallow's alleged involvement in the murder of her ex-husband, who Mr. Cox told police that he had shot, plainly bears upon the issue of whether Miss Vallow and Mr. Cox had an ongoing conspiracy that preceded the core acts alleged in this case. As such, Lori Vallow's previous conduct easily meets the reference standard. In fact, this information goes straight to the heart of Mr. Daybell's potential defenses, including any defenses that he did not commit the crimes alleged, that he was not engaged in a conspiracy, and that he had no knowledge of what occurred. Chad Daybell had no knowledge of what had occurred, but Lori could go on a freaking dang text message and tell Chad Daybell, I didn't get the money. Chad Daybell had no idea that Alex and Lori had done this to Charles Vallow. Give me a break. This alternative perpetrator evidence is inconsistent with and raises a reasonable doubt of Mr. Daybell's own guilt, such that Mr. Daybell has the constitutional right to introduce the evidence regardless of state evidentiary rules. And you know what? I don't think that Judge Boyce is going to allow this stuff out of Arizona to come in to this case. This should be about when Lori and Alex and Tylee and JJ came into Idaho. From then in jurisdictionally, that's when all of this conspiracy can be legally taken care of or whatever, because it can only be in Idaho. I know, and everyone else should know, that if they could get that in with Lori and Alex, and the fact that Arizona didn't charge Chad, it would look exactly the way that John Pryor's saying it would look. That Lori and Alex was in a conspiracy long before they even got into Idaho. Because Lori's been charged. She's been charged in Arizona, and Chad hasn't. So if he's got to go there, he's letting them know that he feels like this is, he's even talking about regardless of state evidentiary rules. State evidentiary rules include jurisdiction. And this again goes back to hearsay. It also goes back to whether or not the judge would admit this, that it would prejudice Chad's co-defendant, Lori. Moreover, because Mr. Cox is now deceased and cannot be called as a witness, Mr. Daybell will likely need to introduce statements that Mr. Cox has previously made to the police, as well as other pursuant to hearsay exceptions. And hearsay exceptions, I haven't really delved into that yet, but can Alex Cox interview in Arizona talking about how he got in a fight with Charles Vallow and all that? I mean, how could that be entered into evidence showing that Lori and Alex was in a conspiracy before coming into Idaho? A joint trial would create a conflict in the fundamental trial rights of Mr. Daybell and Miss Vallow. If Mr. Daybell presents a complete defense, Miss Vallow will be denied her confrontation rights. But if Miss Vallow's confrontation rights are respected, then Mr. Daybell will be unable to present the testimonial statements of Mr. Cox, which bear upon the critical issue of his involvement and whether he had a conspiracy with Miss Vallow. Well, this goes back to if the conspiracy part, the state in the indictment on murder says Lori, Chad, and Alex Cox, other named and unnamed. John Pryor saying that if Mr. Daybell presents a complete defense, in other words, if he is brought in there and he's able to do everything the way that he can do it under Idaho law, then it would mess with his co-defendant, and it would deny her confrontational rights, and vice versa. If Lori's confrontational rights are respected, then that Chad will be unable to present the testimonial statements of Mr. Cox, which bear upon the critical issue of his involvement and whether he had any conspiracy with Miss Vallow. And folks, listen, John Pryor wants to make it look like that it was Lori and Alex all along. It can't be any more clear. But what we're talking about here is the state of Idaho has evidence of Chad's behaviors. Okay? What should it matter that Lori and Alex was in Arizona at one time, even though there's plenty of evidence that Chad knew all about this shit? But let's just, for sake of argument, say that Chad never said a word in a text message or anything else. And this was all Lori and Alex. And there's no evidence whatsoever that would prove that Chad was involved in Charles Vallow's murder. It wouldn't matter because, again, this is Idaho. Past bad acts in another jurisdiction, along with an unrelated case, is not, to me, a complete defense. This is all John Pryor wants to do is bring all that in about Charles Vallow so that it can make Lori look really bad, make it look, look, Chad wasn't involved. There's nothing in there. They didn't indict Chad in Arizona. None of that's going to even matter because they have to stick with Idaho. This is interesting. He goes into now if they're convicted, basically, because he's starting to talk about the penalty phase. And he talks about if one or the other expresses remorse in sentencing. And then it's going to make the other person look bad. He says a confession is rightly regarded by the federal sentencing guidelines as warranting a reduction of sentence because it demonstrates a recognition and affirmative acceptance of personal responsibility for criminal conduct, which is the beginning of reform. This creates a substantial likelihood that in assigning mitigating weight to one defendant's voluntary self-incrimination and expressions of remorse, the jury will at the same time treat as aggravating the failure of his co-defendant to produce similar evidence in mitigation. So if Lori wants to get out here and lie, and in sentencing she says, I'm so sorry, I was tricked by Chad's he's definitely not going to go in there and say, I'm sorry too, that it's going to make it look more bad for Chad. Or think about it like this. What if sentencing, both of them get convicted and Chad says, I am so remorseful. I can't believe I did this. She just had me wrapped around her finger or whatever, and Lori didn't. It will make Lori look bad. John Pryor's not only looking at severance, he's looking at, hey, if these are joined together like they are, we're not just talking about the trial. We're talking about if they get convicted, you're looking at other issues that's going to happen because they're co-defendants. The conflict between the Fifth and Eighth Amendment rights of capital co-defendants is especially vexing because the precise points at which this constitutional conflict will arise generally cannot be foreseen prior to trial and cannot be resolved by instructions. The conflict is unforeseeable prior to trial because a defendant will not normally offer evidence of his cooperation or remorse until the sentencing phase. And the reason I thought that was important is he's trying to say whether it's Lori, whether it's Chad, they're not going to try at all in the trial to give differing evidence because it's going to show their involvement. How can Chad offer statements that Lori or Alex had made in the past that proves that they were in a conspiracy together, Alex and Lori, because he's admitting that he knew beforehand. So either way it goes, Chad can't sit there and take up for himself but say, well, I've got proof here. Say for instance, the state had text messages that showed that only Lori and Alex were conversing in text messages. And Chad wanted to use that to say, see, I'm Chad and it only showed Lori and Alex here. Well, all the state has to do is look at the time frame of that and see that Chad himself was with Lori at the time or was at the time with Alex and Lori. You see? So no matter how you look at it, it's going to look like that. I hope I'm making sense. This is a country girl talking to y'all. It says, in a capital murder proceeding in which Mr. Daybell's life is at stake and heightened and meticulous protections apply, the risk of deprivation of his Sixth Amendment rights is too severe to proceed with a joint trial. He's saying because this is a death penalty case, John Pryor says, that this is too severe of a situation to have these trials together. But again, this is a conspiracy. There have been other conspiracy to commit murder death penalty cases in existence. Under the Eighth Amendment, a defendant's psychiatric impairments are factors to be considered in mitigation, not in aggravation, and the fact that these disabilities may render the defendant more likely to pose a risk of violence in the future may not be used by a capital sentencing jury to place those impairments on death's side of the scale. Now, who's he talking about? Is he talking about Lori having these mental things that lean toward the aggravating aspects that she's never going to change? Or could this be Chad? Could there be aggravating things that are brought out in the mitigation and the aggravating factors and all of this and that? You got to think about that. Likewise, the failure of co-defendants to have several family members testify on his or her behalf may be perceived as aggravating or damning. If the co-defendant brings a parade of family members to testify, although the absence of the defendant's family may actually reflect facts about his emotionally impoverished background, that should be given weight in mitigation, not aggravation. Now, John Pryor's saying, if Chad doesn't have a lot of people come to, and this is in the penalty phase, if he gets convicted, and he doesn't have a lot, but say Lori does, or Chad has a lot of family members, has all his children come in, and Lori has no one to come in on her behalf. Whoever doesn't have the family there, the jury who's deciding on the penalty phase could say, well, look at all these family members. This is a mitigating thing. This is good for the sentencing of this defendant. Or, in other words, if one of the co-defendants didn't have anybody there, that would look like an aggravating thing. And so that's what John Pryor is bringing out in there. He's not just talking about the trial itself. Because in the trial itself, the only thing he really brings up is the antagonistic defense. Now he's bringing up other stuff. If this is all the way seen through, he's trying to let Judge Boyce know that it's not just the trial. This is the penalty phase. This is things that's going to happen that's going to be it's going to be out of hand. In a joint sentencing hearing with conflicting mitigation, the jury will be invited to choose which mitigating factors are really mitigating and which should be minimized or even treated as aggravating. In other words, if Chad and Lori they get convicted, and then we're getting into the penalty phase. Well, what if there's more stuff in favor, good things about Chad and bad things about Lori? And think about it like this. What if there's more good things in mitigation that lean toward Lori having this terrible childhood, and Chad's childhood wasn't bad. He grew up, everything was fine there. There was no signs of anything bad going on. John Pryor wants to make it clear that there are different mitigating and aggravating things that are going on here. And it's up to a jury to decide, is this mitigation? Is this something that's going to look good on Chad or Lori? Or is this an aggravating factor, which would be, i.e., death penalty, basically, or life in prison? Each capital defendant is entitled to an unencumbered jury evaluation of the true gravity of his crime and the extent of his own moral culpability, and not merely to a serial ranking as a co-defendant in which the loser gets death while the other is spared. And I'm going to tell you what, John Pryor ain't stupid on that point. If anybody gets the death penalty, it will be Chad Daybell, because he has not expressed any incompetency or a background of anything bad. He does have all these children, which Lori killed her children. She's got Kobe left. But the bottom line is that this John Pryor is bringing to Judge Boyce's attention. Second, multiple defendant jury sentencing risks another decisional process which might be called bootstrapping for death. This occurs once the jury decides to sentence the first defendant to death. That defendant's case then becomes a sort of benchmark for death against which the co-defendant is measured. And if this happens, the second defendant can avert death for himself or herself only by establishing that the differences between the the difference between the death sentence defendant's culpability and his own is great as the immeasurable gulf between life and death. If he cannot establish so dramatic a difference between the death sentence defendant's case and his own, the jury can be expected to feed him from the same spoon. In other words, if you can't show a big difference in what these two assholes did, John Pryor is saying they're all going to get the same dose, and that is both of them get death. And because that would be something that this jury would see, it would be duplicative. Then they would be more apt to say, well, if one, just because one did more actions, or Lori was the mother of the murdered, she deserves it worse. The bottom line is that it wouldn't matter. They would both be fed from the same spoon. Despite charging the co-defendants with conspiracy, has little to no direct evidence that the two co-defendants have actually acted through agreement. That's what John Pryor wants to believe, but there has to be an established agreement for the both of them. And there's nothing more telling about an agreement to murder children than the actual mother. Just absolutely. The only things left is a storage room full of the children's winter clothes and a bike and a scooter. This woman, and photo albums and blankets. This woman made an agreement with Chad Daybell. And the bottom line is that from the evidence that we've seen alone, there is no doubt that Chad and Lori knew exactly. They knew exactly what happened to the kids. And you would have to believe that Alex and Lori's so in love with Chad, right? She's so in love with Chad that she wants to bury her murdered children that her and Alex did and not tell Chad at all. Think about how stupid that is. There is no possible way that Alex and Lori did this by themselves. Some people say, well, just because those children's bodies were found on Chad Daybell's property doesn't mean that he murdered them or conspired to murder them. In fact, I said a long time ago, I said, wouldn't it be weird if police showed up on the back end of my acreage here on my property and found dead bodies back there and said, you did it, KJ. Because those bodies were there, you did it. Folks, just because bodies are found on someone's property does not make them guilty. What does make them guilty is if they are having a sexual affair with the person, and the bottom line is her kids just happen to show up on the property dead and murdered, burned up, chopped up, duct tape, trash bags. He gives some possible scenarios about how all this would work out. He says he's talking about the trial judge granted severance. He's talking about another trial. Said, in this setting, each defense team will act as a second prosecutor against the opposing co-defendant. The choice required between the two theories presents so sharp a contrast that the jury, in crediting the core of one defense, must then necessarily disbelieve the core of another. Worse yet, caused the jury to unjustifiably infer that the conflict alone should result in both being found guilty. Additionally, the gravity of the sentence sought especially implicates the societal interest in convicting only the guilty. The dual prosecutor quandary is a particular concern in this regard. He's talking about that it's as co-defendants, right? You got Pryor and you got Archie. They would have to be, in a sense, as they're defending their own client, they would have to basically be trying to chip away like a prosecutor would of their co-defendant and vice versa, and how this would be a big quandary. It says capital in a joint trial, capital accused with diametrically opposed defenses, as here, may not only attempt to minimize their own role, but also present their mitigation case implicitly or by design to redound to their co-defendant's detriment. In such a scenario, co-defendant, in effect, locks arms with the prosecutor, stressing the aggravators are applicable against the adversary co-defendant. In other words, what he's saying here is that when it comes to the sentencing and all this and that, it would be like whoever looked less guilty would absolutely try to blow the other one out of water in sentencing by kind of like a metaphorical way, by the prosecutor, which is the state of Idaho, along with one of the defendant's co-counsel, trying to blow the other one out of the water. You see what I'm saying on that? Several of our federal trials have severed co-defendants' trials due to similar concerns about antagonistic defenses and choosing between restricting co-defendant A's defense or permitting co-defendant A's attacks on co-defendant B, either option resulting in prejudice. But he doesn't know any of this. He doesn't know any of this yet. Given the mutually antagonistic nature of the defendant's positions, a joint trial would require that this court repeatedly adjudicate multiple evidentiary and procedural disputes relating to inter alia redaction, precluding portions of a witness testimony, and constructing procedural workarounds designed to prevent prejudice against each defendant. In other words, if you're going to do this, if these, in an antagonistic defense, and what it comes down to is whether the judge thinks that this is an antagonistic type of situation, whether they are on a collision course with the evidence itself. And the judge can see quite clearly. He gets to look at all the discovery that's been turned over. He doesn't get to see the work product of the state or the defense teams. But the bottom line is John Pryor saying, if this happens, then you're going to have to do all these workarounds. You're going to have to do everything, all these different things, procedural things, jury instructions. At sentencing, you're going to have to do this and that and all that. Because if you don't do these things, which is going to be a lot of work on your part, Judge Boyce, then it would be prejudice for Chad Daybell. And then, of course, he wants to say there are efficiencies and advantages in single-focus trials. The time needed for jury selection is significantly reduced. The number of defense challenges is halved, and only one defense counsel conducts voir dire questioning. It is easier to apply the rules of evidence given these considerations. It is far from certain that the time required for two separate trials would, in total, be substantially greater than the time required in a joint trial. So he gives him another thing that he thinks. It's going to be easier, Judge Boyce. Sever these cases. A severance is additionally appropriate because Mr. Daybell requires a continuance in order to adequately prepare a defense, and Ms. Vallow has asserted her right to a speedy trial. Well, like I told y'all 2 vids ago, that's a moot point now. That point that he points out, they have put off this trial in January. The judge, he said that there are competency issues with Lori and all this and that. So, he does say to adequately prepare for a defense. Well, John Pryor's not going to have to go to trial in January. So he is going to get more time. So his point here makes no damn sense at all. In conclusion, for the reasons discussed in this motion, Mr. Daybell moves to sever this case pursuant to Sections 1, 2, 6, 7, and 13 of Article 1 of the Idaho Constitution, the 5th, 6th, 8th, and 14th Amendments to the United States Constitution, Idaho Criminal Rule 14, and other authorities cited above. And so he gives his reasons. And if you go back to the old one where he tried to get the severance and he didn't get it, and Judge Boyce doubled down, there is a lot of this that was in that other one, but he added some more stuff to it. But this is interesting. He had a line item at the bottom saying, based on the need for Mr. Daybell's continuance, the court may also continue Ms. Vallow's trial date if the cases are not severed, holding that a continuance granted to the co-defendant in a joint trial pauses the speedy trial clock under federal speedy trial provisions. So when someone, I think it was Leanne Ferguson, talked about the Speedy Trial Act, John Pryor's letting them know that you can do this, permitting tolling of the speedy trial clock for good cause. Interesting, is it not, that he said that? He said permitting tolling of the speedy trial clock for good cause. This was out before Archie asked for it. So somehow, some way, whether it's a coincidence or not, they have been somehow been working together to get this trial moved off even further. So the bottom line is this. John Pryor does not want his client tried with Lori for a myriad of reasons. He gives his arguments. And again, where is Archie's motion to sever? I don't see it anywhere. You would think that he would do a motion for severance, but that's not happening. Only John Pryor, which leads us all to know there's absolutely no doubt that Chad Daybell is trying to distance himself from Lori. And however he thinks he's going to put this all off on Alex and Lori, it's absolutely not doable. Because number one, Chad Daybell going on the stand saying Lori told me this or Alex told me that, unless there's corroboration in the evidence, and it's corroborative and it's factual. It's not an inference, but it's actual factual evidence. Chad Daybell can't. That's hearsay. He could make up anything he wants to make up. Number two, would he really go on the stand? And is John Pryor worried that Lori would go on the stand and put this all off on Chad? Because the same thing would happen with her. She was the mother of these children. There is no excuse for this hussy. She should have absolutely protected and loved her children. and been there for her children. So, Chad Daybell can say it was Lori and Alex, and Lori Daybell can pretend that it's Chad and Alex, or just Chad, or whoever. The bottom line is when it comes down to it and they're convicted, John Pryor's already thinking ahead. He knows that when they are sitting there through this process of this penalty phase, that there are things that are going to look better for Chad than it is for Lori, and there's some things that are going to look better for Lori and not for Chad. But then again, this goes back to jury instructions. This goes back to the way that Judge Boyce implements the trial, doing his workarounds and everything to make everything legal and cemented. To do what? To give a fair trial and due process. There's no way Judge Boyce is going to sever this case. I don't care how long Lori is going to be incompetent. I just don't believe it. Because think about it like this. They've got at least till October of 2023. That's what John Pryor wanted. Remember that? He wanted a continuance. So they've got all that time right there that they could spend. He can't be bringing up now, oh, y'all put Lori back in the mental health facility and this is unfair to my client. We want a speedy trial, or we want our trial through the Speedy Trial Act. He can't do it. He's already been in his motions saying that he wants a continuance. So he can't back. 1 minute he's ready for trial. Next minute he's not ready for trial. The bottom line is through his own defense of Chad Daybell, he's put this off for over 2 years. And continues to do so. And so we'll just have to see what happens on October 13th. The judge is not going to sever this case, in my view. And by the way, in Bruton, one of the most common grounds for a motion to sever concerns the potential use of one defendant's statements, which implicates another co-defendant. An out-of-court statement by a defendant who has chosen not to take the stand at trial is inadmissible against his or her co-defendant. That's all I need to know in terms of a Bruton rule. In Bruton, the court ruled that in a trial of multiple defendants, it is insufficient for the judge to instruct the jury to only consider such a confession against the declarant and not against any of his or her co-defendants. The likelihood that the jury will be unable to perform such mental gymnastics is so great that the co-defendant's Sixth Amendment right of confrontation would be violated if the statements were admitted into evidence. And the key at all that is admitting it into evidence. Judge Boyce is not going to admit anything in terms of statements, and we're talking out-of-court statements, that's going to prejudice either one of these defendants. So, it says in State versus Fox, the North Carolina Supreme Court applied Bruton and ruled that extrajudicial statements by non-testifying defendants can only be admitted into evidence if all portions which implicate co-defendants are deleted. And what remains is not prejudicial in the defendant or the state. The general rule in Bruton and the specific provisions found in Fox are reflected. Under this statute, if a defendant objects to the use of a non-testifying co-defendant's confession at their joint trial, and if the confession would not otherwise be admissible against the defendant, then the prosecutor must either A, sever defendant's trial from the co-defendant's trial, or B, not admit the co-defendant's statement into evidence. So the question is if there are statements that Lori and Chad made, okay, and this is a Bruton thing, could there be enough evidence to implicate an agreement between them and a conspiracy to commit murder in their behavior or any other thing outside of the statements? Can the state prove the conspiracy to commit murder without showing statements that Lori made to Chad or Chad made to Lori outside of testifying? You see what I'm saying? Again, we don't know if Chad or Lori's going to testify, but we're talking about Bruton. We're talking about statements made outside. The state is not going to be able to depend. Say there is a text message where Chad said to Lori, the kids are safely in my backyard or something like that. That's going to be, those are statements outside of him testifying in trial. You see what I'm saying? So I hope all this made sense. What I'm trying to say is that Judge Boyce is not going to sever this case. You can be sure of it. Lori can't run from it. She's not going to be committed for the rest of her life. They're going to get her taken care of, and her and Chad Daybell are going to go on trial together. So, leave your comments. Let me know if you think, leave me a comment saying, KJ, I don't know what the hell you're talking about. It's hard. It really is. But what I wanted to make clear is the antagonistic defense would be where all the evidence would be different for each side of it, right? And because it was different for each side, the evidence would collide. But because they both line up, because they did so much together, just as these two co-defendants in the original case that decided all of this, the Sever versus the United States, two people saw that the box of cocaine was there. And yes, there was a probability that one didn't know about it, but it was highly unlikely. And then the box was there with them both, and that was proven. So the same goes for these children's bodies. There's no way that Chad didn't know the children were in his backyard. And if he knew they were in the backyard, what else did he know? He knew they were murdered. And there's no way that the mother of these children didn't know that the children were in the backyard and that Alex and Chad did all this. It all lines up. It's conspiracy, evil conspiracy that Chad, Lori, and Alex did together. So, I love you all. Have a great day. Leave your comments and keep on looking.